Hello, everybody. Justin Stivers here. Thank you guys for tuning in, listening, and or watching another episode of the Stivers Show. Very excited about my guest today, Kelley Keller with the Keller Law Firm. Kelley, what's going on?
Hey, how are you? Like,
Good, good, good.
good day to be alive.
Good day to have a peacock in the background. Love that. That's
I
awesome.
know. And any day I'm talking to you is a good day.
Hey, there you go. That's true. Well, I'm excited about our conversation. So I know, and I'll let you kind of introduce yourself, but you are a guru, intellectual property attorney, kind of specialized. I know you do a lot of trademark, copyright work, really all over the country, all over the world, it seems like. But I know we got a cool topic we're going to discuss. But before we kind of dive into that, maybe tell us just a little bit who you are and what you do.
Yeah, absolutely. So I own the Keller Law Firm. It's a intellectual property and small business boutique. We're based in Pennsylvania, where I live. But because intellectual property is generally governed by federal statute, I have clients that come from all over the country, which is makes it really cool. And then anybody in the US who's doing business abroad and we're protecting their property abroad, or people abroad who are doing business in the US and we're protecting their property here. So it's really cool because we have this just really interesting, diverse, all over the place client base. So it never gets boring. I basically say if you're a business and you're commercializing a brand, then we should talk. So I'm like the worst person to be like, who's your ideal client? I'm like,
Dang it, that was my next question.
yeah. But the thing is that but just by way of quick background, I've been in the IP space since 1996 when I graduated from college. I worked for a retired law professor right out of college for about 8 years in DC. And it was really cool because he was a retired IP guy. And I had no idea like what was a trademark. I mean, I didn't know anything. I was 22, straight out of school, but by working for him and his work with a lot of understanding how like intellectual property works in trade deals and things like that, I kind of learned by osmosis. And so after I worked for him for about 8 years and turned the proverbial 30, I went to law school and was in DC a total of about 15 years, and then I've been in Pennsylvania for 10. And 2021 is 10 years of the Keller Law Firm. We're like still
Congrats.
here, which is
Congrats.
like, after how many ups and downs, right? And do I even want to be a lawyer anymore? Conversations.
That's next podcast.
But like for everybody, especially out there listening, if you're a solo or a really small firm, you've had that conversation more than once. But we're really excited and I'm happy with the place that I'm in, especially with the way that the world has shifted writ large in the last 5 years, but especially in this last year, where people understand that if you're not creating content or building a brand that is highly scalable and distributable or online, then it's going to be tough to stay in business. So that's really my jam. Let's talk, brands online and getting people to fall in love with you.
Well, I'm not going to ask who's your ideal client, but I do kind of have a question. If we can, summarize it, if it's possible to summarize, how do you, like, who needs to be hiring you? Like, when do you know? Because everyone, like, for example, this show, I put out a lot of content. You put out a lot of content. Like, a lot of people do a lot of different stuff. So, like, is there a threshold, a type of content? Like, when do you need to start having that conversation about whether it's copyright, trademark, whatever it is? If that's a simple answer, it's probably not.
Yeah, it actually is. And I'll tell you, I use like this little 3-part test to decide whether or not you need to be seriously considering protecting your intellectual property. So before I say the 3-part test, it's important to understand that intellectual property, such as your creative content that you've captured, whether it's in a video, blog, a podcast, or if it's your brand name, um, that actually can be owned just like your house or your car. So if you think about under our law, generally, you can quote own it without formally registering it, but it'd be kind of like owning a car without having the title. I mean, you still have it and you didn't steal it, but it's pretty hard to prove. So the question becomes, should we like formally register our intellectual property and formally secure title, which gives us this whole range of benefits? That's really the question we're asking and answering. And I always say it's a 3-part test. And the first is it is that content something that makes you unique and different from other people in the marketplace? So if it's something like it's, a lead magnet that you're going to download that's got like 5 simple tips, but they are sort of ubiquitous things that people could find anywhere. They just happen to want to get them from you. That's not making you particularly unique. But if it's a course that you've created, or if it's some other type of process or methodology that you use, now that's something that makes you different. So it's distinguishing, is it actually part of like your distinction? That's question one. The second is that thing actually part of your competitive advantage, in the sense that people will pay you for it versus somebody else because you have an edge on the competition for whatever reason? It's reputation, maybe it's process, it's customer service, whatever. Is that piece of property truly helping you make money? So it's helps you, you could have something that distinguishes you, but it's more of like marketing collateral. Then there's something that actually is part of your competitive edge, which helps you make money. People want to pay for that. So if the answer to those two things is yes, then the third question is, are you willing and able to enforce it if somebody steals it? It's a really practical question. If you're going to have your brand name and you're going to register it as a trademark and somebody rips you off, are you going to say, well, they didn't mean it, so that's okay? Or are you going to say, that's my property and you can't take it without my permission? So it's an attitude of, are you willing and able to say, these are the boundaries around my space and I need you to stay out? And if they disagree, that you're willing to follow through and pursue it. So if you're not willing and able and ready to actually enforce it, and that doesn't mean you have to be a jerk and go, fly into federal court in 2 seconds, then don't worry about registering it. And I find that test really helps people start to say, okay, I get it. And if we wanted to summarize it sort of in the ultimate bottom line, it's like, would you be really, really, really mad if somebody stole it? Like really mad and feel betrayed?
Do you have that like summarized that you send to like prospective clients? Because that's great.
Um, yes, it's in my
Is
head.
that trademarked? Is that your?
Yes, I have it in like 47 blog posts all over the place, but it's really a question that in the intake, when I'm talking with my clients, we weave those questions in. Like I'm asking them questions to tease this out of them. Because if you say to a client, is it part of your competitive edge? A lot of times they don't really know what that means. But if I say, you really dig in and ask them, are you mad if somebody took it, and do people pay you for this thing? Because if the transaction fee of protecting something exceeds the return on investment, then like there was no purpose in doing it. But it's always getting that sense on measuring ROI. And I think that taking a really practical approach helps clients see that the investment in the legal protection matters or it doesn't, and then they can make a much more educated decision about whether it's worth going to the expense, because transaction fees are high. Filing fees, legal fees, it's highly specialized work. So it's not it's not just $100 here and there. But yeah, I mean, it's really important to get into the head of the client, and that's how I do it. But I'm not sure I have it in a perfect
Yeah.
example.
Well, no, I think
will
that's,
after this.
yeah, I think that's great, because I think, I hear, and, a lot of new businesses, startups, like before they even have like the service that they're going to do or the product, they're like so consumed with the brand and the trademark, the copyright and all of that. And I guess it depends, but I think, people listening to this it would be good to go back and kind of, use that test to kind of determine whether or not it's necessary. But I want to shift a little bit, because before we started filming, we were talking about something interesting. So politics,
Yeah.
fun conversation, fun topic.
But not controversial in this context.
But not controversial. Everyone gets along. It's really easy. Good Thanksgiving dinner table conversation. But you kind of brought up a good point, that or I'm interested to hear what you kind of have to say about this topic, because you're saying lawyers and maybe just businesses in general who are using their business as kind of like a platform, or just sharing their own beliefs, could get them into some sort of hot water. Is that kind of right, or what's going on with that?
Yeah, no, it's really, really cool. So and that's a really important question. So thank you for asking. So especially with the political environment, and you have people who are now a lot of business owners, a lot of people who are sole proprietors or just have very, very small organizations. we know that sort of psychologically, they're not, even if they have a limited liability company, they don't like separate themselves from the business. They are the business in the sense of they personally are the business's core asset. Whatever their knowledge and expertise or their ability to make something is, people are buying them and the sort of products or services coming from them. It's a very personal feeling. So when somebody, uh, when a business owner uses the business platform to talk about politics or make a social statement or say anything that is likely to attract an audience and repel, you're going to attract some people, repel other people, but it doesn't have anything to do with the actual product or service or how it works. So it's not about marketing to get people to buy from you, but it's about getting people to either like you or saying, I don't want you to buy from me if you don't believe in what I believe. So what I think is important, if business owners want to do that, and then lawyers who advise business owners to be paying attention, is to say, it is fine if you want to use your business platform to make political statements, to establish a litmus test for people you want to do business with. That's fine, provided two things. Your litmus test is not discriminating against a protected class. So under federal law, you can't say, I will only do business with XYZ. But you're basically saying, if you don't believe like me, I don't want you to do business with me. If you're going to do that, you need to make sure of two things. One is that you are intentionally shifting your brand from a product or service into a cause brand. You are intentionally adopting a public social position. For example, Ben and Jerry's ice cream. Very, very clear that they have a political agenda. That's part of their shtick. It's part of what we call their brand promise. When people buy from them, they know that the owners have a certain social stance. They make it clear, and that attracts people to them. It's really, really intentional. Just like when Nike decided to use Colin Kaepernick and their advertising, it was a very intentional statement that we're actually taking a stand on one side of the river for social justice or whatever it is. So for smaller businesses, when you do that, you want to make sure that it's intentional, because it will have an effect on you. You may gain a lot of customers, but you also may lose a lot of them. So there's that, But the second piece of it is to make sure that you are not taking advantage of or misusing the information and that your customers or prospective customers have provided to you, or the trust they have placed in you. And this is what I mean. If you are a business owner that collects personally identifiable information from people in the form of an email, IP address, cookies or other tracking technologies on your website, and you're doing that for purposes of improving your service or marketing, and you have a privacy policy on your website, you are telling people what you will use that information for, and you are legally required to comply with that. So if you turn around and you take that information, whether it's on an email list or if it's targeted advertising online, using the PII of those who have visited your, online space, and you start promoting your political position, you may very well be violating not only your privacy policy, but the CAN-SPAM Act, which is essentially the federal law that says you cannot just email people on a commercial basis without their consent. And there's a couple of ways you can get consent, like you have a longstanding relationship with them, or they actually click the box and say yes. So what's really important is for a business owner, and that's people who own law firms, financial services business or widget makers or, any other type of thing. So I sort of say brand owners and content creators, if you're going to be political, ensure that it is intentional, because you can never go back. You are taking a stand, You are saying that as part of my brand and my offer, it matters that you know where I stand and I only want people who align with me to buy from me. That's intentional as a business. And then also that if you choose to add political content in and distribute it to your audience in a way that is generally subject to any type of privacy regulation, you need their permission, you need their consent, you need to tell them, I'm going to change the way I use your information and give them an opportunity to opt out. Somebody came to me as a client and their information was being misused, I would start filing can spam violations. And it's really a strict liability statute, punishable up to 42,000 per instance. So it could get really ugly if you're not careful. So the bottom line is be really intentional and be smart. People give you their information because they want something from you. And if it hasn't been your ideas on your political position in the past, that probably hasn't changed.
Yeah. A couple things. First, you said Ben and Jerry's, and then I kind of checked out because I was thinking about their ice cream, and I'm going to get myself some Ben and Jerry's after this. Uh, second, second, no. So is that, how does it apply to? Because where I see a lot of this, I probably see it mostly actually realtors, because I'm kind of in that space a little bit. I see a lot of realtors, political views, and I see a fair amount of attorneys, their law firms, saying things, but I see it mostly on social media. Does that come into play, or is this specifically kind of for using someone's information, contact information, and now using that in the email sense, or does it apply in the social media world as well?
It depends on where they're putting it. If they're putting it on their private social media pages, it doesn't, in terms of there's nothing illegal about that. And there's nothing illegal about putting that information on a social media platform or on your website. That piece of it isn't illegal, but it will have a business impact on you. So you are turning yourself into a cause brand, whether you meant to or not. There's that piece. If you're using the personally identifiable information to target with a Facebook ad, or through sending something on your email list, that's when you could really get yourself in trouble if you're not careful. So it's really sort of put it down the middle. One part of it is probably illegal. The other one is it could either be the best move of your life or the dumbest thing you ever did.
Yeah, I mean, you're going to alienate some people.
Yes.
Right. I mean, automatically. And are you seeing cases being filed? Do you file those types of cases, or are you seeing that?
Absolutely. Mainly because it's important. I think now let me tell you why is privacy regulations, there's all the buzzword of talking about privacy. Currently, the United States does not have any unified or uniform federal privacy regulation. We just look at things, we hear about it coming out of Europe. California has always got sort of crazy stuff going on. So I always say to my clients, why don't you always comply with the strictest standard out there because it's coming? So if somebody out there isn't compliant, I want to make sure that my clients are complying, meaning, how they set up their email marketing, how they use things, et cetera. And then when other people don't comply and we file a complaint, it serves two purposes. Usually we can settle it, but second, it also helps whoever misused the information to fix things, which is, really better for everybody. So this comes up a lot in the privacy space because once you get to a certain threshold, you're serving a certain number of people, or you have data on a certain number of people in a certain geographic region, your business is exposed to massive liability for infractions. So I find it best to get on top of it early on. And we're doing it from a privacy regulation, standpoint, not necessarily from a caused brand perspective, at least in the day-to-day practice. But we talk a lot about what the brand stands for an awful lot as well.
And from a practical standpoint, once, I guess, let's say you've made that decision as a company, as a single member LLC, whatever it is, that you do want to be that cause-based, firm or cause-based individual, financial service, whatever it is. What are there steps that they now kind of have to take to kind of maintain that position?
Yeah, so there's two things you need to do. The first is you need to make sure that you have a privacy policy, privacy standards for how you use any personally identifiable information, whether that's collected on a website, if it's collected in the normal or ordinary course of business, whatever. So you need to adopt a policy and make it public. And then the second thing you need to do is notify your um, your list, whether that whoever that is, notify them by email or however you generally communicate with them, that you are going to start sharing a different type of content and give them the opportunity to affirmatively opt out. But to say, if or even better to say, please click here and say, yes, I want to continue receiving communication. It's just all about consent. So you just say, hey guys, I'm changing things up. And if you still want to hear from me, click yes. If you don't, then we will go ahead and remove you from our list. And that's good for the business owner because they're going to have a more targeted list, but that's how I would do it. So get the policy and then implement the policy.
Awesome. Well, I know we're running up on our time, and I think really great pieces of information, useful information for small business owners, talking about the kind of litmus test to use to figure out if you're ready to do a copyright, trademark, something like that. And then for those people who want to start, exposing people to their political viewpoints, some things they need to do to make sure that they don't get in any sort of trouble with all that. So that's awesome.
Yeah, absolutely. Let me make this one sort of kind of conclusive statement that the Supreme Court told us last October that use of trademarks is really a very, very powerful form of speech. It is protected under the First Amendment, and only the market can regulate what we have to say. The government can't exercise any viewpoint discrimination. Used to be able, not like trademark cuss words or bad names about certain groups of people, et cetera. So literally, when you are looking to put your brand out there, the entire government is saying, we're going to protect your right under the First Amendment. So understand that it's a huge opportunity, but you also have a responsibility to exercise those rights, with discretion and thought for the people who are in your community.
Well, I know there's probably going to be some people out there who want to contact you and probably use your services. So how can people find you? Best way to get in touch and learn more about you?
Cool. You can go to thekellerlawfirm.com and use the contact form. You can email me directly, Keller at the Keller Law Firm. And starting in January, you can go to thetrademarkgirl.com and check out my new podcast.
Trademark Girl. Awesome. I don't know if I can be on it, but all right. Awesome.
I'm the trademark girl. That doesn't mean
gotcha.
you. But anybody who does something in service to a brand, call me. Let's have a chat. It's just awesome. So important. These conversations are crazy important for everybody in this really weird space that we live in now. Because now, like, everybody has a voice. It's just, we have just a really, really interesting space that, if properly managed, is really a force for good.
Awesome. Kelley, thank you so much. I appreciate it.
All right, Justin. Appreciate it.
Talk to you soon.
All right.
Bye.
Talk to you later. Bye-bye.